Okay, foreclosure. A foreclosure is, of course, a lawsuit. People get panicked when they see a lawsuit, a foreclosure suit, because they see the foreclosure is bank versus me, and they think they're being sued. Well, a foreclosure is not a lawsuit against the individual owner or borrower. It's a lawsuit against the real estate to allow the mortgage lender to sell the property at sheriff's sale. When people borrow money on a mortgage, they're signing two documents. They're signing the note, the IOU, I promise to pay you back. Then they're signing the mortgage. The mortgage is the document that says I'm giving you the house as collateral. Foreclosure is about the mortgage, not the note. This is, again, for most non-commercial loans and residential loans. So the first thing to understand about a foreclosure is it's a lawsuit to allow the lender to eventually sell the house at sheriff's sale. In order for them to do that, they have to be able to deliver clear title to whoever's going to buy at the sheriff's sale. And for them to do that, the foreclosure has to give everybody notice, the borrowers. A lot of times people will look at a foreclosure complaint and say, why are all these people in here? There's creditors and the IRS. They list everybody who might have a claim, even if it's not a creditor of yours. They do a judgment search and they see all these people, and if you have a very common name like Jones, you may have a whole bunch of people in there. They want to basically give them all an opportunity to step up and say, yes, I'd like to avoid foreclosure and pay off the loan, redeem. They're trying to cut that out. All right. The most important thing is to look, if you're facing you're served with a complaint, is to look for a docket number that starts with an F. The other thing to understand about foreclosure is that it takes time before an actual sheriff's sale. It takes, again, estimates vary, but figure 9 to 12 months. And during that 9 to 12 months, you're still the property owner until the sheriff's sale or until you've gotten the lender to accept a deed out of your name, if you're the property owner. And that's important to understand because a lot of times people make a mistake of immediately moving out of the house and leaving the house vacant. That actually can make a bad situation worse. So let's talk about that before I get into more of the details on foreclosure. First of all, moving out is not a good idea if the property is safe and habitable. Why? Because you can live in that property. I tell people, tongue-in-cheek, you're living in the house rent-free. Well, if you're in financial difficulty, what's wrong with that? Why should you move out and have to pay rent somewhere else? Secondly, by occupying the property, you can keep it insured. Homeowner's insurance protects the homeowner not only against the loss of their house and the lender from the house burning down or being damaged, but it also protects you from liability claims. What if you moved out of the house, for example, and somebody got in the house, had a big party, started a fire, and the house burned down and burned down the neighborhood? Now you've got all these people suing you, and you've got liability. You can't have homeowner's insurance if the property is vacant. They won't insure it. So stay in the property. That way you can continue to pay the homeowner's insurance, and it's not that much. And you can continue to enjoy the property for a period of time until you can figure out what happens. Meanwhile, you may have freed up some cash that will help you deal with other situations, like, for example, paying for medical insurance, paying for other important needs. And maybe, depending on how things turn out, you can save the house and by a variety of means. Again, HUD foreclosure specialists can help you with that. Bankruptcy may be a way of doing that, but whatever it is, moving out doesn't help anybody. And in fact, it doesn't help the lender because the lender doesn't want a vacant property. If the property is vacant, the lender has to assume the responsibility of maintaining it, making sure the grass is cut, maybe having to board it up, and vacant properties are subject to vandalism. So the lender is just as happy that you're in there with the lights on, keeping the place occupied and taking care of it. You're able to occupy the property until 10 days after the sheriff's sale. We're going to talk more about that. So let's talk more about now the process under the Fair Foreclosure Act. The Fair Foreclosure Act in New Jersey applies if, when the foreclosure is started, you are occupying this property as a residence. Now notice how important that is. There's a lot of important benefits to the Fair Foreclosure Act. If you've moved out of the property before that foreclosure complaint is served, you may have lost some rights under the Fair Foreclosure Act, important rights. We're going to go over that. So the first thing that happens is the lender has to send you, the borrower, a notice of intent to foreclose. It's a letter that will basically say, you're behind on your mortgage, you have 30 days to bring the mortgage current, here's how much money you have to pay. If you don't, we will foreclose. If within that 30 days you're able to pay that dollar amount, no foreclosure. If not, they start the foreclosure process, and that involves basically the filing of a foreclosure complaint, and also filing a document called a lis pendens, which essentially is put in the property records for purposes of protecting the foreclosure process. And at this point, you may start getting a bunch of calls, letters, cards from a variety of people, bankruptcy lawyers. You may get calls or inquiries from people who are promising to solve your problems. Again, one of the things that we've seen, and I'll talk about it, is that people facing foreclosure panic. And when they panic, they tend to become victims. You don't want to do that. You need to understand the process and understand what's going on. So the foreclosure complaint has to be served on you. First, they have to try to serve you personally. If they can't serve you personally, then they can eventually serve by certified mail. I always tell people one of the mistakes you make is to not pick up your mail, not open your mail. I've seen more people that come into my office that haven't opened their mail. I never got anything. Yeah, they got the letter, you just didn't open it. Again, open the letters, especially if they're certified mail. Keep those records, it's important. At some point in time after you've been served with a complaint and a document called the summons is basically that says you've got 35 days to answer the complaint, then you have to file an answer. We're going to talk about whether that's necessary or not. Most times for most individuals, it's not a worthwhile endeavor. But if you don't answer the complaint within the 35 days, then there's something happens called the default. The default basically cuts off your right to file an answer after that. Unless you file motions, there's limited grounds for doing that, but essentially that's what happens. After a default, under the Fair Foreclosure Act, the lender has to give you notice that they're going to apply for a judgment of foreclosure. The judgment of foreclosure, as I'll discuss, is essentially a court order that says, here's how much is owed, and the lender has the right to send the property to the sheriff and have it sold at sheriff's sale to redeem and get whatever money they can out of it. But first you get this letter, and the letter says essentially you have 10 days to write us and tell us how you're going to bring this loan current and how you're going to avoid foreclosure. And if you do that within a 10-day period, then they have to look at that and it give you an opportunity to try to work out something to avoid foreclosure. Lenders actually don't want to foreclose properties for the most part, but they're not going to give away the property. They're not going to let you stay behind it. But if you're in a situation where you might be able to work things out, these are options you need to explore. Anyway, moving forward, this is what a foreclosure complaint looks like. And the most important thing is that it has the docket number starting with an F. And this one says complaint in foreclosure. Anytime in a foreclosure, I get clients that call me and they say, I got served with this paper, what is it? And I say to them, well, does the docket number start with an F? It's a foreclosure. Okay, it's not a lawsuit against you personally. Then when the application for judgment is filed with the Superior Court, the foreclosure unit, usually in 30 to 60 days, a judgment is entered. And at that point, the foreclosure basically sets the amount that the lender is owed and cuts off the right of all these other people, for example, the second mortgage holder, the IRS if they have a lien, judgment holders, cuts off their right to try to intervene and stop the foreclosure. It gives them a free target to go to the sheriff's sale and the sheriff sells. And when the sheriff sells, anybody who was named in that foreclosure complaint as a defendant has lost their right or their lien on the property. So for example, if you own a property with a first mortgage and a second mortgage and 3 judgments, and the first mortgage holder gets a judgment of foreclosure and goes to sheriff's sale, and I buy at the sheriff's sale, if it's all been done properly, I get clear title, and the lender gets some money. We'll talk more about that in a minute. Okay, so the sheriff's sale, the judgment is entered, and now a document called the writ of execution is sent to the sheriff. They get this, the lender gets this from the court. The sale has to be advertised in 2 local papers at least 4 times, once a week before the sale. So there's a period of time from the point that the sheriff gets it before the sheriff's sale can take place. Each owner has to be served with notice of the sale date at least 10 days before the scheduled date. So there is some lead time before you actually get notice of a sheriff's sale. At this point, people will start panicking. I have to move out. Well, you can ask for a 2-week adjournment. You get two 2-week adjournments. So you have another 30 days after that, essentially, before the sheriff's sale. And when the sheriff's sale takes place, and this is, by the way, as a notice of sheriff's sale, gives you some idea of what it looks like. It's usually one long column, and it says how much is owed, and it tells people that this is when the sale will take place, here's the terms. At the sheriff's sale, which happens sometime between noon and 5 p.m., typically the lender will come in and they'll bid a minimum bid of $100 and wait to see if anyone else bids. If no one else bids, the lender gets the property back, and now they're the proud owner of the property. If somebody else bids on the property, then the lender will typically bid up to their upset price. If they're owed $200,000, they'll simply say, fine, we're bidding $200,000. This assumes that no other deal has been worked. Either way, at some point, somebody becomes the owner of the property. The sheriff has to deliver the deed. He's got at least 10 days before a sheriff's sale, the sheriff's deed is delivered. Sometimes it takes longer. I hear sometimes the sheriffs delay on this, and it takes even longer. And at this point, even if you're at a sheriff's sale, I've had instances where people have been able to go to court and ask to challenge the sheriff's sale or to redeem it, but typically that's very hard to do. The times that I've seen it worked was when somebody had a buyer, and the buyer would pay enough for the property to pay off the mortgage, pay better than what was at the sheriff's sale, and we've been able to do that. But that's not typically the situation. If the sale results in a surplus, and this is unusual, but let's assume that the mortgage is $150,000 and somebody bids $200,000, there's extra money, then it goes to pay the lien holders in the order of their priority, and then if there's any money left over, it goes to the owner. This is pretty rare. It just doesn't happen. So as I said, after the sheriff's deed is issued, there's 10 days before the sale, before the deed, and the next question I get from people is, okay, I'm facing a sheriff's sale, what do I have to do? They seem to think that you have to clean out the property. Well, you should take your stuff with you. If you leave anything behind, it's going to be treated as abandoned property. But do you have to spend a lot of money to clean up the house like you would if you sell it? If you want to, that's fine, but you don't have to. Again, people are desperate, so a lot of times they will come in and they'll try to argue with the lender about cash for keys or can I rent from you? I always tell people you can always ask, but don't count on it. For the most part, the lender is going to be interested in getting the property back so that they can sell it, and they'll typically hire a realtor for that purpose.